It's 30 minutes past your scheduled pickup time. You are standing on a curb, gripping your bag, waiting for a vehicle that hasn't arrived. A late taxi means missing a meeting. A late medical transport means missing dialysis or chemotherapy. The delay creates a direct clinical risk to your health. Because you do not hand the driver cash or swipe a credit card, it is easy to internalize the idea that this transportation is a favor, a charity service you should simply be grateful to receive. That mindset creates a dangerous silence. Passengers often endure reckless drivers or wait hours in the cold because they assume reporting the issue will cause the broker to cancel their future rights entirely. Treating this system like a charity strips away your leverage. It forces you to absorb unacceptable risks just to access your own healthcare. In reality, non-emergency medical transportation is a mandatory statutory benefit codified in federal law. Federal law defines medical transportation as a structural bridge, a legal guarantee that physical distance will not prevent eligible individuals from receiving care. Your protection rests on three distinct legal pillars: Medicaid, the Americans with Disabilities Act, and HIPAA, which protects your sensitive health data. Together, these laws convert you from a passive passenger into an active rights holder, giving you legal standing to demand accountability. We are going to decode the specific rights these laws grant you, showing you exactly how to bridge the gap between bureaucratic promises and the reality on the street. Knowing these rules is your only mechanism to turn a precarious ride into a safe, guaranteed medical outcome. The state agencies and brokers managing your rides operate under a strict federal mandate. They must provide the least costly form of appropriate transportation. That economic directive creates an obvious incentive. The system is designed to push you toward the cheapest available options, like public bus passes or standard rideshares. This matrix plots the cost to the broker against your medical necessity. It illustrates how the system's economic gravity pulls passengers toward cheap options. However, the second half of that federal mandate protects you. You have a legal right to the most appropriate transportation for your specific physical and medical needs. You can legally force the broker to move you out of a standard sedan and into a specialized vehicle. The tool to do this is a physician certification statement, often called a medical necessity form. Getting this document requires you to coordinate with your doctor to fill out the paperwork. Although that takes effort, once it is filed, it legally blocks the broker from assigning you an ill-equipped vehicle to save money. A completed physician certification statement is your ultimate legal defense against cost-cutting measures. When you step into an approved medical transport vehicle, you are legally entering an extension of your doctor's office. The transportation companies operating these vehicles are classified as business associates under federal law. A business associate is a person or entity that performs functions involving the use of protected health information on behalf of a medical provider. This means they are strictly bound by HIPAA regulations. Your name, your Medicaid ID, and the specific clinic or treatment center you are traveling to all constitute protected health information. If a driver tosses an unlocked tablet onto the passenger seat, leaving your medical destination visible to other passengers, they are violating federal privacy law. Under the HIPAA breach notification rule, you have the right to be formally notified if your transit data is mishandled or exposed during your trip. Medical privacy does not pause while you are in transit. You must actively assert these rights for the entire journey. State Medicaid agencies enforce strict on-time performance standards. If your ride is delayed by over 15 minutes, you have a right to receive an immediate dispatch update and a new estimated arrival time. Under the Americans with Disabilities Act, you are guaranteed equivalent service. A passenger requiring a wheelchair-accessible van cannot legally be subjected to longer wait times than an ambulatory passenger taking a standard sedan. Sometimes the vehicle arrives on time, but the environment inside is unsafe. You might encounter a driver who speeds, uses abusive language, or refuses to properly use the required ADA wheelchair securement straps. If this happens, you can invoke a specific operational tool, the formal Do Not Ride request. Submitting this request does shrink the total pool of drivers available to pick you up in the future. However, it legally mandates the broker to investigate the incident and prevents that specific driver from ever being assigned to you again. You never have to endure physical danger or verbal abuse simply because you cannot select your own driver on an app. There will be times when a broker arbitrarily denies your ride request or attempts to downgrade your specialized vehicle to a cheaper option. When this happens, you have the right to demand a written notice of action, also known as a notice of adverse benefit determination. This physical document is a strict legal requirement. A broker must provide it to you before any authorized service can be terminated or reduced. Demanding this notice triggers your constitutional right to due process, allowing you to formally appeal the decision through a state fair hearing. The trade-off is real. The appeals process is dense, highly bureaucratic, and will demand hours of your time. But forcing the broker to issue a written notice prevents them from quietly cutting off your life-saving care with an undocumented phone call. When the system fails, complaining to the driver or the basic dispatch call center rarely works. Those complaints often go unlogged and ignored. This flowchart maps the escalation path. Bypass the driver, report the broker to your managed care organization, and escalate to state and federal levels. State-mandated beneficiary support systems act as oversight bodies to track grievances and penalize the broker. For violations of the Americans with Disabilities Act on public transit, escalate to the federal level by filing a complaint with the Department of Transportation. If the issue involves a private transportation entity, your complaint goes directly to the Department of Justice. The transportation broker is not the final authority. Understanding this oversight ladder helps you force compliance. The reality of the medical transportation ecosystem is harsh. The system defaults to the cheapest, easiest option available, and it will stay there unless you actively force it to do otherwise. Build your own empowerment scorecard. Know the 15-minute wait rule, document exact arrival times, save your state grievance numbers, and always demand a notice of action in writing. Your next step is to call your managed care organization caseworker today. A managed care organization is a health plan contracted by the state to deliver Medicaid benefits to enrollees. Ask them to provide the exact on-time performance standards for your specific state. Navigating this bureaucratic maze should not feel like a daily battle against the very people supposed to be driving you. SwiftAid Transport operates differently. They prioritize operational transparency, maintain strict regulatory compliance, and ensure every patient is treated with dignity from pickup to drop-off. Go to swiftaidtransport.com to see how a passenger-first, fully compliant transportation operation actually works.